Yes, any mention? May I please, Your Lordship? Lordship, I beg to mention item number 12, my lord. And for the respondent, I have informed the petitioner, my lord.
Yes, ma'am.
Come up after a week, my lord.
I'll have it next week, my lord. We'll have it next week.
After 2 weeks, because next week this court may not be there.
My lord.
On premier by the respondent, not objected to by petitioner. This is matter after 2 weeks.
Obliged.
My lord, similar prayer for item number 14 as well, my lord. And for the petitioner, my lord. I'm praying if this matter can be taken up next week, ma'am. Or after 2 weeks, ma'am.
What should I have for District Council Respondent 1, 2, and 4? Only, my lord, it seems
This is with regard to those fishing things.
fishery, settlement of fishery. It appears it's become infructuous. Let them have instruction.
Fractious?
Yes. It was till 31st of the last month. Since
Yes,
the
yes,
senior
I
is
think
not
that,
here,
that issue was raised
let them
I'll
take
seek
instruction
instruction, my lord, in this matter.
after 2
on
weeks.
premier by the petitioner, not objected to by respondent. This is matter after 2 weeks.
Much obliged.
May it please, Your Lordship. Lordship, I beg to make a mention of item number 16, Your Lordship. Lordship, the Senior Conducting Counsel needs some more time to prepare this matter, Your Lordship. I pray if this matter may be listed after 2 weeks, Your Lordship.
Lordship, they've already informed us, Your Lordship, beforehand.
On premier by the respondent, not objected to by petitioner. This is matter of the 3 weeks.
Highly obliged, Your Lordship.
Supplementary list, item number 1.
May it please, Your Lordship. Your Lordship, this is a petition under Section 439 CRPC for grant of bail of the accused person who have been arrested in connection with this special NDPS case number 27 of 2023 under Section 21C with Section 29 NDPS. This matter is from the lying pending before the special judge Clariat.
What is the stage of the case?
The stage of the case is now, Your Honor, is pending for evidence.
How many witnesses have been examined?
On the day before yesterday is supposed to be the examination of the complainant, but I'm not aware whether the witness came or not.
And how many witnesses are there? Prosecution witnesses?
Prosecution witnesses, nine witnesses, Your Lordship, including the IO.
You said the matter came up day before yesterday.
Day before yesterday for evidence of the complainant.
So the complainant's evidence was recorded?
You know, I'm not aware. I don't have instruction on that. But my ground here, Your Lordship, before the Honourable Court is that on prima facie, there is no case made out against me.
Exactly. That is, you see, that is exactly the point.
Yes.
If you come, on the ground that prima facie, there is no case made out against you. So eventually, evidence will reveal. Evidence will reveal whether you are involved or not. And for that,
We take instruction. But even from the face of the record, from the material on record, there is no case made out against me. If Your Honor will allow me to satisfy on that ground, because Section 37 of the NDPS Act, Your Lordship, there is a rider exception like bail or upon satisfied that there is no reasonable ground to show that I am guilty, bail may be granted to me.
Those two conditions have to be fulfilled.
Yes, Your Lordship. So I will just try to satisfy Your Lordship on that ground.
think before you proceed, Mr. Jarwal, the CD has to be produced. Statement under section 161, 164.
Charge sheet has been annexed.
Charge sheet is there. Irrespective of that, the statement that has been recorded will also be material. Charge sheet has been
Filed, Your Lordship.
And it is annexed also with the petition.
Annexed. Basically, Your Lordship, in this instant petition before this Honourable Court, I have two grounds. One is the on prima facie and also the other is on medical ground. I've annexed the medical certificate of the medical officer, Your Lordship, from Civil Hospital, Juwai, where a recommendation is there, Your Lordship, that I have to undergo surgery for a hemorrhoid. So maybe pending this bail application, Your Lordship, if an interim bail may be granted to me. But for that, if Your Lordship allow me just to take Your Lordship to the on the prima facie ground, so that Your Lordship will understand that there is nothing against me in this case. Simply, I've been alleged to have been involved in the matter only because of the CDR, of the call detail record. Nothing was seized from me. The contraband was seized from a vehicle. The vehicle does not belong to me. And as per the Section 27 Evidence Act, the discovery of the contraband was also led by the other accused person. I'm just a passenger in the vehicle. The vehicle is a tourist vehicle traveling from Manipur to Guwahati. Why I'm going to Guwahati? Because I have my family there, and I've annexed the school certificate of my children also to show that my children are there in Guwahati. Because after the conflict in Manipur, for a secure life, I've shifted my residence temporarily to Manipur. I hail from Chorachandpur, and Your Lordship is aware, Chorachandpur is also one of the area where the conflict is also very heated during the 2023. So I've shifted, and the reason why I was with the co-accused, who is the owner of the vehicle, and who have also led to the discovery, is just so that I will travel to Guwahati. And because I'm also well acquainted with the driver, and because of this CDR shows that I'm well acquainted, but CDR does not says it's not substantive evidence to say that I'm also involved in the peddling of the contraband.
The contents of the CDR would reveal that.
Your Lordship, CDR simply says that I have made a call to this person, and I've got a judgment to support my argument also, Your Lordship, that mere having the call detail record that I was in contact with the co-accused, mere discovery of that fact, it is not enough to say that I'm also involved in
that is true. That
yes,
is true.
Lordship.
The only thing is that it has to be discerned as to whether you have made any calls connected to the offence.
Yes, there is nothing as such, Your Lordship. If Your Lordship can allow me to take Your Lordship to the analysis, CDR analysis, which they have also enclosed. This will be at page 134, Your Lordship. The only evidence that the investigating agency was able to collect to link me with this instant case is only the call detail record, Your Lordship. Here, the remark, Your Lordship, in the analysis, it is to be noted that both the accused person, namely M. Longkumer and Shri M. Tunbyak Goite, the accused before this Honourable Court is Goite, was in touch with each other since 1st June 2023, and several calls were seen in the CDR. The CDR analysis also shows that Longkumer was in touch with Jahangir Alam, another accused person, Your Lordship, from Guwahati, whom he was to give the delivery of the contraband. Further, the contraband shows that Longkumer was in touch with the above numbers, which is suspected to be drug supplier. Therefore, the CDR proved that both were involved in transporting the illegal contraband and had intentionally conspired to commit the crime. This is the only evidence that the prosecution is using against me. Only the CDR, and I'll take Your Lordship also to the charge sheet, to the prosecution story, Your Lordship.
See, these are the records
Matter of trial.
of the number of calls made
Yes, yes,
from you to the
Yes.
other co-accused.
to the accused.
What exactly are the other contents of those calls?
There's nothing as such. There's no recording. There is no recording. There is no
Those-
SMS
yes, Mr. Sengupta.
transcription.
As far as I'm not so conversant with the process of the CDR.
Even myself
Whether it records only the number of calls.
number of calls, only the call number
To and
or
fro,
the details of
or whether
the conversation.
Because that would be material.
There's no call conversation, Your Lordship. I'll take your Lordship to the prosecution story.
But the
Which is at
sections,
page-
No, you, Mr. Jaro, I'm not saying they may not be here.
Yes, yes.
Otherwise, the IO would have,
reflected it.
possession of those.
Yes, yes.
Because they would be subjected to forensic tests.
True, Your Lordship. And in this instant case, they have not proceeded towards forensic, towards retrieving some kind of recording.
You have to
towards,
get that.
My lord,
Try to find out.
my lord, what at this stage, because the sections which has been leveled is under section 21 of the NDPS Act and section 29 of criminal conspiracy. Conspiracy for
21C.
yes, my lord, conspiracy for drug peddling and transportation and everything, my lord. So this will actually connect all the people who are present and who conspired to acquire this illegal contrabands, my lord. So that being the position, my lord, if the call records number itself proves that they were in contact, means, my lord, the clear presumption is that the burden of proof will shift upon them to disprove that. Of course, my lord, at the time of trial,
You see, that is not sufficient. That is not sufficient.
no, that will come
Because
at
you
the
see,
stage of trial, my
When
lord.
you are in possession of a mobile phone, any number of person can call you.
Correct, my lord.
You may be acquainted with a number of person whom you may.
No, my lord,
you
they
may
will get
know
the
or you may
scope.
not
They will get the scope of examining the witness once it is in the trial stage only, my lord. At this stage, my lord, it will not be readily available, my lord.
I'm here for bail, Your Lordship. Trial, we will definitely face the trial, but I'm here on bail. Like whether there are reasonable ground to show that I'm also involved in this drug trafficking. And Your Lordship, I'll just like to take Your Lordship on the query made by Your Lordship on what is the evidentiary value of the CDR. Your Lordship, because in this instant case, I've annexed the charge sheet. There is nothing as such where they have sent for forensic to retrieve some more data to help the prosecution's case. They have simply supplied us the data analysis which shows the call detail record. That also time, Your Lordship, can go through.
You see,
Yes, and even in the prosecution
that is
story.
exactly the query that was made.
Yes, yes. So on
They
that
will go to the
on
merits
that
of the
scenario,
case,
Your
my lord.
Lordship,
At this stage, my
this
lord,
being the backdrop of the matter, Your Lordship, I'll just like to Your Lordship to draw the attention of Your Lordship on this judgment, Your Lordship, 2022 online. The observation on the same issue, Your Lordship, faced by the High Court of Punjab and Haryana, Chandigarh, where reliance have been made on the division bench judgment of that honorable court, para 10, Your Lordship. Para 10.
Yes.
The last two lines of para 10. A division bench of this court, a Narcotic Control Bureau case, was pleased to observe as under. Still further, no conversation detail between the accused Ramesh Kumar Patel and accused Sandeep has been produced by the prosecution. Mere call details is not sufficient to prove that Sandeep accused was also involved in the business of narcotic drugs, or he had any connection with Ramesh Kumar Patel. In view of the above, no case is made out for grant of leave to appeal against the acquittal of Sandeep accused. Para 11 also, Lordship. In the judgment of Gujarat High Court in Yash Yajesh Bhai, it has been observed as under. Having heard learned counsel for the appearing parties, it emerges on record that the applicant is not found in possession of any contraband article. Over and above that, the call data records may reveal that in and around the time of the incident, he was in contact with the co-accused who was found in possession of the contraband. Since there is no recording of conversation Lordship, this is very... Since there is no recording of conversation between the accused, mere contacts with the co-accused who were found in possession cannot be treated to be corroborative material in absence of substantive materials found against the accused. So this is also my argument, Your Lordship, in this instant matter, that relying simply on the call detail record, which shows that I was in contact with so-and-so, with the co-accused. Only that aspect, Your Lordship, cannot pin me, Your Lordship, cannot be a case where I'm also involved in peddling the contraband. Also, Your Lordship, there is a Supreme Court judgment also on this aspect, Your Lordship. This is 2021, 20 SCC 50. This is para 13, Your Lordship. Nine line, Your Lordship, from in para 13. Reliance on printout of WhatsApp messages downloaded from the mobile phone and devices seized from the office premises of accused 4 cannot be treated at this stage as sufficient material to establish a life link between him and accused 1 to accused 3. When even as per the prosecution, a scientific report in respect of the above devices is still awaited. So in this instant case, Your Lordship, before the Honorable Supreme Court, mere showing that the WhatsApp messages downloaded from the mobile phone and devices seized from the office cannot be treated as sufficient material to establish the life link. There has to be some forensic report on that, whether it's genuine or not. And in my case, Your Lordship, it's only call data record. There is no other forensic report to show the call recordings or even a SMS exchange. There's nothing like that, Your Lordship. It's just a detailed analysis, a record analysis, which says that on the so-and-so,
Again, see, those are all matter of evidence.
So part of evidence, I truly believe, but to show that, to inspire confidence on this Honorable Court, there are reasonable grounds to show that I'm not guilty. Your Lordship, in my humble and respectful submission, considering that the case of the prosecution against me is only with regard to the call detail record, nothing was seized from me. I'm not the owner of the vehicle. I'm not a habitual offender. This is my first case against me. Your Lordship, it shows some reasonable ground. I just want to inspire that reasonable ground that I'm not guilty. And therefore, Your Lordship, at this stage, bail may be considered against me. And especially also, Your Lordship, on the second ground that I'm trying to press on, Your Lordship, is with regard to the medical condition. Medical certificate I have annexed, Your Lordship, in this instant application, which is at page 164, Your Lordship. The type copy is at 165. And also, Your Lordship, upon informing the court, the trial court, about my the accused medical condition, Your Lordship, an order dated 19, which is at page 166, order dated 19 March 2024, Your Lordship, was passed. If Your Lordship may allow me to read this. Accused person, Longkumer and Goite and Jahangir Alam are produced via VC from July present today, and on being asked, accused Longkumer and Jahangir Alam are healthy and fine. Seen the medical certificate of the accused Goite issued by Dr. B. Sutanga, MNHO, July Civil Hospital, stating that the accused is suffering from grade 4 non-thrombase external hemorrhoid treated conservatively. Patient can be planned for open hemorrhoidectomy at July Civil Hospital. However, the patient's relative wants to take him to other higher center for treatment. So, Your Lordship, the medical condition of the accused has also been acknowledged by the court, and the recommendation of the doctor have also been recorded by this order, where the doctor have also recommended for a surgery, hemorrhoidectomy, which is a surgery, Your Lordship.
But it is the observation of the trial court that the same can be done at
Yes, the same can be done, but Your Lordship, on the ground, because it's a pile condition, Your Lordship, where proper diet is also important, Your Lordship, not only treatment but proper diet. So this is, I'm not pressing hard on this, Your Lordship, but it's just to help to add points to why I'm praying for bail. One is on prima facie. There is no, I mean, my humble and respectful submission that I've tried my level best to impress on this honorable court that there are reasonable ground to show that I'm not guilty. And on the second ground is on medical, that even medically also, Your Lordship, if bail can be considered. And if Your Lordship decides to call for the record in this instant matter, maybe an interim bail may be granted. And that is the
What
purpose.
interim bill is required?
Your Lordship, in case, Your Lordship. Also.
If this is a bail application.
Yes.
If the petition is to be decided, to be decided.
Bow down, Your Lordship.
I think records would be required. Yes, Mr.
My lord, at the stage of bail, my lord, we are only to see the prima facie case, my lord. We are not to see whether he is guilty or not guilty. That can be only ascertained in the course of trial, my lord. That is my first submission, my lord. The other thing is that, my lord, regarding his health, the honorable court has already indicated that it can be done under the supervision.
He is not pressing for
yes,
this.
my lord.
Because
So,
the court has given direction.
at the stage of bail, my lord, we cannot determine the guiltiness of the accused persons now. Otherwise, it will amount to giving him acquittal, my lord. The moment we take that into account and consider the bail, my lord. So,
You are Mr. Sen Gupta.
my lord.
You are mistaken. You see,
No,
we are
I beg to
only on the point of prima facie.
no, prima facie case, my lord. The prosecution.
Prima facie, he may appear to be innocent, but if evidence is taken, it might be otherwise.
Subject to trial.
That is
Or
what.
prima facie, it might appear that he is guilty, but when evidence is finally proceeded, it would turn out that he is innocent.
He may be.
So
Maybe that is a question of probability, my
we are
lord.
not on that.
So at the stage of bail, my lord.
At this stage, what the court is required to do is to go through the records, find out what is there. If there are evidence that prima facie he is guilty, fine. Section 37 will come into play. If not, because we are dealing with a matter under Section 37.
My lord, the case is also very serious in nature because this involves drug peddling, my lord, which is very serious in nature, and the burden of proof is basically on the accused person in all kinds of.
In such a case, personal liberty versus societal interest will be balanced.
My lord will kindly examine and pass appropriate order as deemed fit and proper.
You produce the record on Monday?
Monday, my lord.
Sufficient time. That's it.
My lord, on 10th, my lord.
10th, I think this court will not be. I think
then
from 10th the court will not be sitting.
On 9th, my lord.
9 would be too tight.
My lord, on just after the opening, it will be slightly difficult to.
Bring it on 8th. You can do it.
On 9th.
8th.
On the 8th.
Heard Mr. T.L. Jarwan, Learned Counsel to the petitioner. Also heard Mr. S. N. Gupta, Learned Counsel, appearing for the state respondent. On hearing the submission made, this court is of the view that the records, relevant records, including the case diary, we produce for perusal. Accordingly, the state respondent is directed to produce the said records on the next date fix. Place this matter on 8th.
From daily list, item number 1.
Your Lordship, in this matter, I got the instruction, Your Lordship, SLP is been filed, Your Lordship.
Yesterday, Your Lordship, they are filed in SLP,
So
which
just I
is
got the
not yet
communication today.
registered nor numbered. But the
But still,
procedure is,
still,
Your Lordship,
this,
there are 3-4 stages before the matter is listed. That will take a week's time before it's listed before the court.
So we'll give them time,
Your Lordship, after 10 days,
2 weeks.
after 10 days, then we'll know what will be the outcome in Supreme Court also.
Mr.
This is the
Adeplat,
communication discipline.
Mr. Adeplat has submitted that against the impugn order, impugn judgment, and SLP has been referred before the Honorable Supreme Court and has therefore prayed that this matter may be adjourned for the time being. Accordingly, on submission made, matter is adjourned. This is after 2 weeks. I think in 2 weeks' time we'll be able to.
So, Lucip,
One and
item number 6, Lucip, I paid for this extension of time. So it will be same order then.
Same order.
Same order, Your Lordship.
6, I say order.
1 and 6.
Fine.
This communication may be taken into part of the record. Your Lordship.
Yes, that is a communication, nothing is there.
Submission will do, Your Lordship.
Fine.
Item number 2.
May it please your lordship. Your lordship, we are newly appointed counsel in this for the petitioners in this case, your lordship.
Have you filed your power?
We'll be filing today, your lordship. Since
Last occasion you said you will file it in the course of the day.
yesterday only the brief has been handed to us, your lordship. We are newly appointed yesterday itself, your lordship.
But Miss Learned Counsel for the petitioner who has submitted that on being appointed, on being engaged by the petitioners, the execution of power has been completed. However, this same could not be produced for this court today, and as such some time is paid for in this regard. On premier, the same is allowed. This is matter after 2 weeks.
Highly applied.
Item number 4.
Lordship, here the accused expired, Lordship.
Oh,
He was on interim bail, madam.
He was on interim bail, and we,
at least he has expired a free
Lordship,
man
the post-mortem report. Yeah,
at the relevant point of time. Sad to say, but those are facts of life.
These facts of life.
Ms. P. Learned Counsel has submitted that the petitioner in course of this proceeding has since expired, for which this is the
Post-mortem report of the accused
you don't
person.
have a death certificate.
Death certificate, no, we because he expired only on 1/4, so we are yet to get the death certificate.
Has since expired on 1/4/2024.
Petitioner is the brother, your
petitioner.
lordship. Petitioner is the brother, the accused person.
Accused person. Accused person. What's his name?
Shri Shakil
Mehboob Sheikh.
Shakil Mehboob
Sheikh.
Sheikh. Kung to accordingly, this petition will be treated as infructuous. Accordingly, the matter is disposed of as infructuous.
Item number 5.
Lordship, here we have filed the application, but since the court was on holiday, so after vacation only we filed. So matter might be coming up tomorrow, the impleadment petition which we have filed.
We have received a copy yesterday, my lord. The application is not listed today.
Application is not listed, might be coming up tomorrow.
On pre-admit by the parties, list is matter tomorrow.
Obliged, Lordship.
Item number 8.
Yes.
I'm appearing for the university. No, these matters are pending for a very, very long time. Now, I think on the last occasion she filed an amendment, whatever the miss case is there. Well, I have gone through. She has already filed. My learned senior friend has filed already the amended writ petition. I have gone through, my lord. I'm ready for the hearing. So
My
far,
lord, I have not filed, my lord. The application is not yet allowed, my lord. If they don't have any objection, my lord, we have served a copy, my
How
lord.
come you say that they have already filed and you have...
Yes, they have given me a copy.
My lord, we have served a copy, my lord, but since the application is not allowed, my lord, till now, so we have not filed it in the court. So if lordships
What I
allow,
suggest, whatever it may be, my lord, I am ready. Otherwise, I have gone through
In
it.
fact, I think the last time around, so this court has observed that matter has to be heard.
my lord.
So
But in that case, my lord, this matter can be taken up tomorrow, my lord.
Where
We'll
is your
file the application, the amendment petition.
Where is your application?
My lord, application is miss case number 46, my lord. 46 of 2024, my lord.
But Ms. R. Datta, learned counsel for the petitioner, who has submitted that an application with a prayer for amendment of the prayer in this writ petition has been filed, and as such, it is therefore prayed that this application may be allowed and the original application petition may be allowed to be amended suitably. Have you filed the amended?
No, my lord. I'll file it today itself, my lord.
They have served me.
I have served a copy, my lord.
Accordingly, on prohibit, the same not be objected to. Accordingly, on consideration of such prayer made, the same not be objected to by Mr. S. Sen, learned counsel for the respondent. Who the petition is allowed. This petition is allowed. The main writ petition is to be suitably amended. Petitioner is directed to file the amended writ petition on the next date fix.
You can take it up tomorrow also. This is 2015 matter.
Monday, my lord, Monday. If lordship allows.
But lordship, make it clear, my lord, no adjournment at all.
No more adjournment.
2015. I think this is the oldest matter. I think.
On Monday, my lord.
Not oldest, but yes, perhaps.
15 matter.
This is matter on Monday.
My lord. Well, item number 9 also, my lord. Same order maybe.
Till 11, my lord.
8. What about 8?
My lord, 8 is my lord.
Oh, sorry. 8,
Item
8,
number
9.
9. Lord, 10 is not part now, my lord. It's separate matter, my lord. We have.
Similar. My contention is, my lord, these are all, lordship has decided on Surajit Datta, my lord. These are all arising out of SCP, MSCP. So, some way they are linked.
My lord, no, let it come up Monday only, my lord. But item number 9, my lord, we have to file an amended application. The application has already been filed, my lord.
Okay, fine. As far as 9 is concerned.
My lord. All the matters may come up on Monday, my
So, that is 8 and 9.
My lord.
The same order, 8 and 9, no? 10, this is matter on 8. 10 and
11, my lord. In the 11th, the petitioner died, my lord, and then I will not be able to.
Yes, you're supposed to file an application for substitution.
Yes, my lord. I am not able to contact properly with them because. Anyway, I will not disturb
If I may be wrong, but if I remember correctly, in course of these proceedings, the petitioner, the deceased petitioner, has since retired, isn't it?
Yes. No. Prior to filing of this, he retired already.
Okay.
After retirement, then he started filing this.
So whatever the case may be, as far as the the initial pensionary benefits, he has already received.
He has received pensioner benefits, but
except for
the upgradations and this miscalculations, this are there. So that is what he was fighting for. we as maybe Lordship, let the other matters carry on in the meantime, because the other hearing will take time. In the meantime, I'll make an endeavor.
You take your time.
Yes.
This is only. He deserves to rest in peace.
Yes.
Katuka 11, as paid for by Mr. P.O.N, Learned Counsel for the petitioner, the instruction sought for as far as substitution of the deceased petitioner is concerned is allowed to be filed before this court in due course. This is matter after 2 weeks.
2 weeks, ma'am. This will not come along with this.
No, we'll detach it.
Highly obliged.
Item number 13.
My lord, the conducting counsel is on next, my lord, Mr. N.D. Shurai.
Let me start, my lord, because it's been quite pending, and this is in the meantime he can join, because which court? I think court number 2. Court number 2 is rising at 12.
Just inquire, my lord, in the meantime.
No, what is this case about, Mr.
My lord, this is a case where we are claiming for the equal pay for the equal work. That is the basic, that is the only issue, my lord. Whether we are entitled.
What is your status?
My lord, we are a long-standing casual workers, my lord. We're casual workers, and we retire, my lord, on the age when an employee becomes age for retirement on superannuation, and there is no break, my lord. And there is an agreement also where our services gets automatic renewal, my lord. There's an automatic. We don't have that. That's not that. Only on need basis they will call us. If not need, they will not go. We report every day till the day we retire, my lord. That is the case. And we are doing all. We are all grade 3 employees, my lord. We are doing all the same work, same nature of work, same time, and same amount of work, same risk.
See, Mr. Ewan, I think that is well settled, of course.
Yes,
the only thing now is
the entry
with regard with the mode of
employment, my lord. Yes, my lord.
That would have to be considered, because
yes, my lord.
Some are appointed regularly.
Yes,
and some are not.
Yes.
So they may be doing the work.
Yes.
My lord, for all we know, you may be doing much more work than the others, but
yes,
that's not the issue.
Yes, ma'am. Now, my lord, that issue, my lord, has been already dealt, my lord. In the case of Jagjit Singh's, my lord, reported in 2017, 1 SEC 148, my lord.
Justice Kehar.
My lord, yes. Justice Jagdish Singh Kehar, my lord. Justice Kehar and Justice Bobre, my lord, S.R. Bobre. They have discussed as not less than 50-60 cases, and they have come to a final conclusion. And that point, my lord, that point also has been taken care, my lord. So before going even to the facts of the case, it is not even disputed. So therefore, the law, my lord, if I can place this law, it will be crystal clear, and will come to conclusions that, my lord, this will be squarely covered in our case also, my lord. So therefore, my lord, this will be a little lengthy. I will like to read this one by one, my lord. This will clear out all the doubts, my lord. How the entry, whether in order to claim the equal wages, you need to have a regular appointment. You need to have the qualifications. All these have been taken care in this judgment, my lord. We have submitted the judgment, my lord, already. No? We have submitted the judgment, my lord. It's 2017. 1 SEC 148.
My lord, if I pray, AG is on the legs, my lord, before the court, my lord, Apex Court. So he has requested this matter can be taken on some other occasion, my lord. He's arguing on behalf of the MECL, my lord.
He's in the other court?
No, my lord, he's before the Supreme Court right now, my lord. He's having matter, my lord. So he was ready, my lord. However, he texted since the matter has already been called, so he's not able to join, my lord.
Well, they have so many deputies also, my lord.
Not really, my lord.
They have two additional AGs.
My
They
lord,
have
here is on behalf of MBCL,
This
my lord.
is
I think
MCL.
my friend is not.
MECL.
MBCL has
MECL.
different
He
council
would not be
panel, my
appearing
lord.
as AG.
They don't fall under the state
He would
government
not be
panel.
appearing as AG.
My lord?
He would not be appearing as AG.
My lord, he will be appearing as a senior counsel for MBCL.
Okay, okay,
So we have a different panel, my lord.
okay.
That
My lord, then
he should not. When it comes to benefits of employees, he
yes,
should not delay.
yes, my lord.
Accommodation has been sought for on behalf of the respondent MCL on the ground that the declared senior counsel, Mr. A. Kumar, is
Not available, my lord.
personally indisposed. The prayer has not been objected to by the declared counsel for the petitioner. Accordingly, matter is adjourned. List the same on 9th. We'll have it on Tuesday then.
Tuesday, my lord. Actually, my lord, my friend is more than competent to handle this case. If
You get your instructions.
Yes.
If
My
so,
lord, we are assigned matters to matters, so my lord. So though I may be here physically, but then the clients have a preference, my lord, in which matters which counsel has to appear. So I cannot go against the desire of the corporation.
that's up to you.
my lord, obliged.
Item number 15.
My lord, in this case, we have just received the additional affidavit, my lord. So we are praying for some time to obtain instruction in this matter, my lord.
What is required here? What is this case about?
It's about gradation list, my lord. Gradation list. So my lord, we are the copy which has been given to us also is not so legible, my lord. So we would be requesting if they could have provided us some legible pages.
Give a type copy.
Type copy would have been better, my lord, because I do not know whether the copy given to the court is legible or not. All these pages, my lord, page number 24, 25 and all, all these are few pages starting from 15, 16. Otherwise, we have received the additional affidavit, my lord. We will obtain instruction, but then it would have been happy had it been a more legible copy, my
What
lord.
has been done through this additional affidavit? What have you sought to bring on record?
Lordship, since we have applied through RTI and we have received the RTI and we have want to.
No, that is not. I'm not saying how. What's the mode of getting the information? What you have to find here?
Because these there are important notification and office memorandum, which is very important.
Okay.
For
It talks about the vacancies existing and how much vacancies was there, my lord.
Give him a clear copy.
Yes, yes, Your Lordship.
Are you filing your response?
My lord, after obtaining the instruction, only we will be in a position to.
What response would you file? These are all official notifications.
Still, my lord, we'll have to get an written instruction. Thereafter, only we'll pray accordingly, my lord.
Mr. S. Gupta, additional senior GA, has submitted that the additional affidavit, copy of the additional affidavit have been supplied, have been received by the state respondent. It is prayed that it is prayed that a response may be allowed to be filed to the same if so instructed. On payment, the same is allowed. This is matter to 2 weeks. Okay. In the meantime, you give them a clear copy. If you don't have a clear copy, photocopy from this
we have
the records here. It makes no difference.
Chair.